Hello everyone, I welcome you back to our channel. This is Legal Mindset Adeba, and today we are going in for criminal law 1. We are going to look at an interesting topic of parties to a crime. Others call it modes of participation. This is a fundamental topic. It is sacrosanct. It is paramount to your passing of the exams, because at times it is set as a problem question. So I urge you to be very keen such that you understand every aspect under the topic. Subscribe such that we can continue. Now, by the end of this session, you should know what are the parties to a crime. You should also know the responsibility, the criminal liability of the different parties to a crime. You should know the fundamental legal principles governing the topic of parties to a crime. Hang on until the end of this video, where I shall give you an interesting case, a locus classicus case governing the topic of parties to a crime. I dedicate this video to one of our students, Navideo Famat. She studies from IUIU, Kabuja campus. This video is for you. So, what are the parties to a crime? It's like you have committed an offense jointly. Every person in that crime is responsible, is liable to a certain degree. And to define a crime is a behavior, either by act or omission, defined by statutory or common law. So, there are different statutes which define crimes, and in Uganda, the Penal Code Act, Cap 128, defines crimes, and it also lays down their punishment. It is key to note that the Constitution in Article 28, Clause 12, stipulates and provides that any person shall not be convicted of a criminal offense unless that offense is defined and the penalty for it is prescribed by law. So, all crimes are provided for by the law. The Anti-Corruption Act provides for those corrupt crimes. The Anti-Homosexuality Act, the Penal Code Act, very many. So, Smith and Organ, in their book Criminal Law, defined a crime as a public wrong. Hope you have now understood what a crime is. Now, it is not only the person who carries out the actus reus of the offense that is guilty for a crime which is jointly committed. All the offenders in the process are also held liable. And among those offenders, we have the accessories before the fact, the accessory during the fact, and the accessories after the fact. So, the accessories before the fact include the aider, the abettor, the procurer, the counselor. The accessory during the fact, we shall see the principal offender. The accessories after the fact, we shall also look at them under section 366 of the Penal Code Act. Now, section 19 of the Penal Code Act, Cap 128, provides for the parties to a crime. We are going to look at one by one so that we understand them. And if a scenario comes, it will be very simple for you to understand and to break it down. So, allow me to start with the procurer. So, who is the procurer? If you have your friend who studies procurement, what are they studying? Because to procure literally means to facilitate something, to provide, to strategize. You see those government procurement officers on the hospitals, they bring medicine which is not available. They procure. So in law, a procurer is someone who facilitates a crime. They go on to provide money to someone to kill for them another person. They give you a murder weapon. That is the procurer. We have said someone who facilitates a crime. And the person, the procurer does not reach the scene of crime. For them, they just facilitate. And if you go to section 19, subsection 2 of the Penal Code Act, Cap 128, it provides that any person who procures an offense, who procures another person to commit an offense, is also part of the offense and is guilty of the same offense. That is the position of the law. So, I urge you to be very keen. Let us now continue to another party. The counselor. So, who is the counselor? As you hear the word counselor, we have had counselors in our high schools. For example, me, I have a number of counselors. Mr. Ismail, he guides me somewhere. A counselor is a person who gives you advice. So, counseling in law means giving guidance or support that leads a person to commit an offense. For example, my friend here, Counsel Joshua, wants to kill Counsel Timo. But I go on to tell him, if you kill him by a gun, the bullet will sound and they will catch you. You just strangle him. That is counseling. Maybe I tell him, you wait for him when he's coming from campus at around 8 p.m. It will be a good time. That is counseling. That is a counselor. So, it is important to note that the counselor does not go at the scene of crime. If you go on to look at the case of R versus Kaliem, a case of 1985, Queen's Bench, page 808. This case provides to what amounts to counseling and procuring. And in this case, the defendant was charged with counseling murder. He had instructed the principal offender to murder the victim, his wife. The principal offender decided not to do the crime. But he said, let me go there for formality because they have given me their money to do the crime. Now, when he reached the doorway, she knocked and the wife opened arrogantly. So, he got tempered and hit the wife with a hammer to death. So, the defendant was guilty of murder, of counseling murder, because the murder happened as a result of counseling the principal offender to go to his house and kill his wife. Because it was in the scope of what he counseled. That is counseling. So let us look at another party. But before, a procurer and a counselor do not go at the scene of crime. The procurer facilitates a crime. The counselor advises another party to commit a crime. Now, who is a principal offender? We are now on the principal offender. The person who actually does the crime is primarily responsible for the crime. To define a principal offender in law is a person who actually commits the actus reus of the crime. So, there are specific examples. For example, me and my friend here, my friend Counsel Joshua, we are planning to go and rob a bank somewhere. But on reaching there, Counsel Joshua bangs the padlock. It means Counsel Joshua is the principal offender. because it's the person who has actually done the actus reus of the offense of breaking. So if you go to section 19, subsection 1A of the Penal Code Act Cap 128, it shall define for you the principal offender. And if you look at the case of R versus Karim, the principal offender, the woman Karim hired to kill for him his wife, was the principal offender. Now, let us look at another party, but before looking at the other party, you should know that the principal offender goes to the scene of crime and is an accessory during the crime. So, let us continue and look at another party, the aider. Who is an aider? Many of you have aiders. An aider is someone who helps, someone who enables you to do something, someone who assists you. Those are the words I urge you to use on aider. Don't wiseacre. Use someone who assists, someone who helps, someone who enables the principal offender to do the crime at the scene of crime, because the aider is always at the scene of crime. And if you go to section 19, clause 1, paragraph B and C of the Penal Code Act Cap 128, it defines for you what amounts to aiding. And it states that any person, every person who does any act for purposes of enabling or aiding another person to commit an offense is also part of that offense. Colleagues, that is an aider. And if you go to the case of R versus Kogan and Leak, a case of 1976, Queen's Bench, page 217, Leak was convicted of aiding and abetting rape of his wife. Why? Because Leak persuaded Kogan to have sex with his wife. You get? That is abetting, persuading. But he told him his wife had consented to have sex with him, Kogan. So Kogan did it in a sense that the wife had consented, but the wife never consented, and Leak was convicted for aiding and abetting rape. So that case crosses over to an abetter and an aider. Let us now look at an abetter. Who is an abetter? As you hear the word abetting, encouraging, an abetter is a person who encourages, who persuades another person to do a crime. You remember our fights during childhood, where our friends could fight and us champions were standing there saying, you beat him, beat the nose. That is abetting. You are encouraging another person to do a crime. And in law, an abetter is a person who encourages or persuades another person to commit an offense. I encourage you to use the words I'm using. Now, section 19, subsection 1, paragraph C of the Penal Code Act provides what amounts to abetting. If you continue to look at an interesting case of R versus Jogi, a case of 2016, Jogi and his friend were taking some drugs and drinking alcohol. Now, the friend to Jogi went inside and went inside the house and started to stab the victim fatally. But this fool Jogi was outside shouting encouraging words, encouraging his friend to continue stabbing. So, Jogi was convicted for abetting murder. Now, if you look at the case of Katushabe versus Uganda, a case of 1977, High Court Bullet, page 187, court held that a person who aids or abets the commission of an offense is equally liable as the principal offender. Be very careful. Don't where you see a crime on streets, run away. You will be held liable. So that's abetting. And now we can look at the case of Willox versus Jeffrey, a case of 1951. All England law reports at page 464. And in that case, Willox, a journalist, unlawfully abetted Coleman Hawkins in contravening Article 1, Clause 4 of the Aliens Orders of 1920, which restricted artists of such kind, alien artists, for example, Coleman Hawkins, to perform in the UK. So Willox welcomed him from the airport. He went on to record his show. So he also, after published the show in magazines, newspapers, journals, the bottom line in this case is that Willox encouraged the commissioning of the offense which was prohibited by the Aliens Orders of 1920. And he was convicted for abetting that offense. So now let us look at our last part, accessories after the fact. So on accessories after the fact, I urge you to be very careful, because we said we have the accessories before the fact. We talked about the procurer, the counselor, the abetter, and the aider. We said we have the accessory during the fact, and that is the principal offender, the person who does the actus reus of the offense. Now we have the accessories after the fact, the people who come after the offense. I urge you to look at section 366, subsection 1 of the Penal Code Act Cap 128. It provides that a person who receives or assists another person where to his or her knowledge that person is guilty of an offense, in order to enable him or her escape punishment, that person becomes an accessory after that offense. The bottom line is, if you know that such a person so and so is guilty of an offense, but for you, you go on to help them, to hide them, to bring a car, and you take them away from the scene of crime, you are becoming an accessory after that crime. Take an example like my friend Counsel Joshua goes to the bank. This is an example, and he steals 1 billion. Now he calls me and tells me, Hamza, I'm here, but I have 1 billion. I've stolen it. Then for me, I drive my car in a rush. I put Counsel Joshua. We run away. We go deep in Masaka. We hide. I hide him at my place. I'm an accessory after that offense. If you continue to section 366, subsection 2 of the Penal Code Act, a wife cannot be an accessory after the fact where the offender is his husband. That is an exception, because a man and wife after marriage, they are considered to be one. You get? So section 367 of the Penal Code Act states that any person who becomes an accessory after the fact to a felony also commits a felony and is liable on a conviction if no punishment is given by court to imprisonment of a term of 3 years. And if you continue to section 368 of the Penal Code, it shall provide that any person who becomes an accessory after the fact for a misdemeanor is guilty of a misdemeanor. So now let us look at joint offenders, because they also fall under this category, parties to a crime. I urge you to look at section 20 of the Penal Code Act Cap 128, which provides that when 2 or more persons form an intention, a common intention, to prosecute unlawful purpose in conjunction with another, and in prosecution of that purpose, an offense is committed, each of them is deemed to have committed the same offense. That's why you see cases of Uganda versus Anyao Milton and another, the other person was the helper. And if you go to the case of Uganda versus Beliu and others, criminal case number 0118 of 2014, judgment of Justice Stephen Mubiru. Justice Stephen Mubiru held that the accused persons are jointly liable for murder because the death resulted as a result of common intention of all the accused persons to kill the deceased. If you have found this information helpful, I urge you to share with your colleagues. This is Legal Mindset at the bar. Thank you for subscribing. Keep the comments coming. That is our video on parties to a crime. Thank you very much.